right, let's get into this next section. So when it comes to Bryan Kohberger, we talked about this a lot. I mentioned it. I've gone back and forth with some of you in the comment section about Bryan Kohberger and his ability to appeal. You all are saying, oh, he doesn't have an ability to appeal. He can't appeal this sentencing. Well, we're going to hear from an attorney over at Law and Crime and talk about exactly what Judge Hippler meant when he said, obviously, you still have certain rights, Bryan, and you can appeal everything that you've heard today. Let's see what that would look like moving forward. And I want to get your thoughts on this as well.
I want to bring in somebody who knows all about criminal defendants and their rights to appeal. He is Philip Dubé. He worked as court-appointed counsel in Los Angeles County for many, many years. So, Philip, there's been a lot of talk about what Judge Hippler said regarding the Garza v. Idaho case and the fact that Bryan Kohberger can appeal. So clear up for us what exactly this means, because people heard what Judge Hippler said and they thought to themselves, wait, I thought he waived his right to appeal. I thought he waived all of his appeals.
Nope.
Yeah, unfortunately, it really is sort of a right without a remedy for the state. Back in 2019, ironically, out of Idaho, the U.S. Supreme Court handed down Garza versus Idaho. And at issue in Garza was a drug defendant. He pled out, took a deal, but then decided to appeal. He calls his counsel and said, I need you to appeal. And of course, counsel said, no, it's ill-advised. It's not a good idea. And of course, he independently appealed, and it went all the way up to the high court, and the court reversed. And the court found that that is not a strategic decision on the part of defense counsel. It's a mere ministerial act versus a discretionary act or a tactical or strategic decision to file a notice of appeal. And if your client so instructs you, you must file it. The question is, what happens if you don't? If you don't, all it really gets you is an appeal. It doesn't vacate the conviction. It doesn't vacate the plea. You just go back into court and you get to be heard on an appeal, which triggers a whole other body of law, which we call the Anders versus California. Sometimes they call it the no merits type brief. And typically what that means is the appeal lacks merit and it's frivolous. And there's a procedural type mechanism to either get it dismissed or to go forward with a bare bones brief. But in the end, there's really nothing to litigate on appeal. It's just a last ditch effort after buyer's remorse to try to get out of prison.
So,
which would be interesting to see. Again, we talked about the control issues with Bryan Kohberger. Could this be another control move if we're saying it really doesn't do anything but cost the state money? Why not? What risk do you run of appealing? It seems like you might as well take your shot at it. And if your attorneys can come up with something now that a lot of these documents are being released, maybe they can point to some sort of misconduct. I mean, who knows?
Let's say Bryan Kohberger does go to Ann Taylor after sentencing. And this is all, of course, we're speaking hypothetically. And he says, you know what? I want to appeal. And Ann Taylor says, okay, but you waived your appeals. And he says, well, I want to appeal. So she just has to file the notice of appeal, or how would that?
That's correct. When your client instructs you to appeal under this decision now, and I don't agree with it, frankly, I really don't. And I'm a bleeding heart, commie pinko, former public defender, but in the end, to me, a deal is a deal. But when you look at the rationale of the decision, we could talk about that momentarily. The law requires that you file that notice of appeal and you've discharged your duties as defense counsel. It's now up to appellate counsel to sit the client down and say, you know what, I've reviewed the entire record below. I've looked at everything, and we have a knowing and voluntary, intelligent waiver by you. What do you feel you need to litigate on appeal? Well, we can go through a host of issues that maybe were beyond the scope or sort of outside the realm of the plea that nobody even considered. And you never know. Maybe there is an issue. I think we talked offline about, well, what if he decides that he didn't get a fair shake because he does have autism? And that should be properly raised on appeal. The problem with that, we talked about this, and even if appellate counsel sat him down, is all the Atkins hearing would get him and a finding of being autistic is life without parole, which is what Ann Taylor got for him anyway. So what are we doing? Why are we litigating an appeal when in the end, everybody really got what they wanted on the defense side? So what does the law call that? A frivolous appeal. It would be frivolous. And appellate counsel should probably submit in the state of Idaho. They call such I guess, appeals of frivolity, Anders briefs. And it comes from Anders versus California from the 60s, where when you feel your client's appeal has no merit, you file a brief on their behalf. You don't necessarily join in the client's will and desire to appeal, but you're letting the court know that there's really no merit to the appeal. And then the court typically will review the entire record below. And if the court agrees, the appeal is dismissed.
What a waste
So you're
of
telling
resources.
me the only way that Bryan Kohberger can appeal, because he's waived all of his appeals, and as far as Garza v. Idaho goes, it's just filing a notice of appeal, and that's it?
That's it.
All this is?
And then they're back.
That's
in court.
exactly all.
Further in filing an appeal?
If, let's assume, a week from today, Bryan calls Ann and says, Ann, I appreciate everything you've done for me, but I am instructing you to appeal my plea. Well, based on the edict pronounced in Garza, she must file it. And if she does not, let's just pretend she digs in, doubles down, and says, Bryan, I'm not going to do that. I want to save face. I want to save my reputation. I have integrity. We had a deal. Well, let me tell you, the courts are going to step in and find her ineffective.
Wow.
And Bryan has the right to effective assistance of counsel under the 14th and 6th Amendments to the Constitution. And the last thing you want on your jacket as a defense lawyer is that finding.
Yeah.
So this is all
And Bryan
about
would definitely do
filing a notice of appeal. It's not moving forward with an appeal.
Correct. And then what happens from there, appellate counsel gets appointed for an indigent appellant. Appellate counsel will review the entire record to see if there's any issues that need to be briefed. If counsel feels there's no issue, they will prepare what's called an Anders brief. Sometimes we call it a no merits brief. They send a copy to the defendant. If the defendant feels that maybe there are issues that appellate counsel missed, he or she can raise them. And then you submit it with the court. If the court finds that the appeal lacks merit, the appeal is dismissed. Well, let's say the court finds after reviewing everything that there is an issue. Appellate counsel will be ordered to remain on the case, cannot withdraw, and will be ordered then to brief the issues spotted by the court. And then you go in for oral argument, and then you wait for remittitor and, of course, any decision from the higher courts. But practically speaking, the only obligation defense counsel has at the trial level is to file a piece of paper called a notice of appeal on behalf of a defendant seeking the appointment of appellate counsel and the ordering of any and all transcripts for the appeal.
You know, there are, I've covered so many cases over the years, Philip, where everything seemed like it was done. And then years pass, things come up, and it's not done. And of course, after a conviction, the burden shifts to the defendant to prove their innocence, to raise these issues. It's their burden if they are going to raise issues. Does Bryan Kohberger, after he's sitting in prison for a while, decide, this really stinks? What did I do? And does he somehow find somebody to say, hey, let's look for some federal relief here? Is there any avenue where he tries, even though it might be fruitless, he tries to file something? And he's, this case, oh my God, the media coverage, everything was just against me. They used the IGG, which we know has been litigated and found to be, constitutional. It did not violate his rights. So what do you think? Because I feel like there are so many cases where it seemed like it was over and then it wasn't.
The bottom line is all counsel has to do is file a notice of appeal. It doesn't guarantee a reversal. It doesn't even guarantee litigation of all his complaints or all his points on appeal. All it guarantees is that an appellate lawyer will be appointed to look at the entire record below. That's it. And I must say that
imagine if this got reversed and then you got to go through all of this again. What would happen there? I mean, could it potentially go to trial? This is
one of the worst times in our U.S. Supreme Court history for someone such as Bryan Kohberger to be taking on the high court. And I'll tell you why. Garza was just handed down in 2019. And the majority in that opinion was Sotomayor, Roberts, Ginsburg, Breyer, Kagan, and Kavanaugh. The landscape of that court has changed since then, as we all know. The dissenters were Clarence Thomas, Gorsuch, and Alito. Well, now we have a whole new constitution, no pun intended, of our U.S. Supreme Court justices, where I could see them overruling that prior precedent and saying, no, we don't agree. And we think, given the change in policy considerations, we're going to overrule Garza and pronounce a new rule of law in Kohberger versus Idaho, and say that counsel does not have a duty and is not ineffective for failing to file a notice of appeal after a plea. So he has to be careful, because this really could affect the appellate criminal landscape throughout the nation, not to mention his own individual case. And I'm telling you now, given the makeup of our court, I could see them overruling Garza.
So what are
Interesting. So he's saying, yeah, he ain't going anywhere. Y'all said in the chat, he's never getting out of there. I'm with you. What do you guys think about this? Is there a chance this happened based on what you know about Bryan Kohberger, how you see him and his attorneys conduct himself? Is this something he'll maybe shoot for to see if he has a last shot of taking some sort of control? I'll be interested to see what y'all think in the comments and in the